Recording in progress.
Good morning, everybody.
Morning.
Morning.
I'm watching all the numbers go up here.
Good morning.
I see Di. Hi, Di.
Hi, everybody.
Hey, Mar. Are you on here, Mar? Marley.
I'm sorry. I just need to know.
Happy Thursday, everybody.
Saying the sound isn't working. Can you hear me, Di?
I can't hear you. Yeah, happy Thursday.
Yes.
You can hear me, Di?
I call every night.
I can.
Yeah, for
Guys, we're trying
December
to get you on.
2021.
All right, Mar, it says it's recording. Is that recording on my end?
I have the December bill.
It's from Marley Wood.
Where's Mar? Guys, I'm going to
It says
mute
monthly
everybody.
water bill,
because
December
we're getting a
2021.
We're getting a lot of
Yeah, so no, like I get it. I understand.
Okay, I muted everybody because we were getting a lot of feedback there. So if Matt, Marley, and Di want to unmute. And the participant list is still climbing, so we'll give it a few more minutes. Do not see Matt on here yet.
Here. You see me?
Oh, I hear you.
I'm here. I see myself.
I
see
see you.
There you are. I see you. Hey,
Listen,
Mar,
let's
Huh?
keep the comments to a minimum about the Matt video. It does seem as though the camera adds 10 pounds and removes a lot of hair.
how many cameras do you have on you?
Well, I have a whole set here.
Haha. Mar, this is saying it's recording. Does that mean it's recording? I didn't push anything. Is it just auto recording?
Yeah, I set it up like I do every time that says automatically record meeting. And I got a message on my end. I'm sure everybody else did that says
Yes.
this meeting's being recorded.
All right. I just want to make sure I knew where it was going because after the one on Monday, we don't know where that one is.
It says it records it on your computer, I believe.
I know, but Monday I was on my phone, so it doesn't record on there. So we'll have to figure that out.
So
Before we begin, because the participant list is starting to even out a little bit, I want to introduce our newest attorney. Riley, are you on here? Can you unmute yourself and say hi?
I am. Hi, Janelle. Hi, everyone.
There she is. This is Riley. We kind of stole her from the courts. She used to work for the courts and do the conferences and stuff, and she is now our newest associate at our firm. So you may see her face on Zoom in New Jersey court with you. So that's Riley, everybody. She's awesome. All right, so I'm going to get started here. If people jump on, then that would be great. They can kind of join in if they missed the beginning. Like I said, this will be recorded, and my lovely tech support guy, i.e. my husband, will be uploading it to our social media and our website later this week, or probably early next week, because it's already Thursday. So we just wanted to have a quick update. This is probably going to be 20 minutes, half hour tops, to let you guys know what's going on in New Jersey since everything kind of has changed in the new year. I'm going to let Matt run with a lot of it, but I just kind of wanted to give you a quick base overview on some of the procedural changes, and then Matt's going to go into some of the substantive stuff, because I know people have a lot of questions about this Fair Chance Housing Act, or whatever the heck it's called. He knows a lot more about it than me. So he'll go into a little bit of that, but I just kind of wanted to give you guys an update. Things are changing rapidly in New Jersey. We sat for a year and a half of not being able to do cases. We could file them, but they sat in a queue. And I think at the last we heard, I think the last number Matt gave me is when they opened the doors this fall to open the virtual doors this fall to start doing cases, there was a 70,000 case backlog. To make matters more complicated and worse, and I'm sure as you guys have all seen, because Diane has been reaching out to you nonstop, they took every one of those cases and added one, sometimes two conferences before we went to trial. They're basically statusing these cases in a something called a case management conference prior to us getting to a hearing. And so every one of these cases have now basically have to have double court appearances on them. And to add insult to injury, before we can get to the case management conference, as I'm sure you've all heard from Diane, we need a plethora of documents that the courts are requiring to be uploaded to their system before we can get to the conference. Case information sheets, the lease, the ledger, your registration, different certifications, both on our end and on your end. And every one of these cases have this paperwork that needs to be filled out in addition to everything that needs to be submitted when we file the case. So Diane has been basically had to take this backlog, out of the 70,000 cases, I don't know how many we had, but get all this information on those backlog of cases, plus all of the cases going forward. And it all has to be uploaded to the courts. And then we just learned the other day, Riley was telling us that she was in a case management conference. And if we do not have that information uploaded, Riley, what did they say? 10 days before the conference? Do you remember?
It varies county to county. I believe it was Monmouth who said 10 days after they uploaded deficiency.
The others are 5.
5 days. Okay, so it's anywhere from 5 to 10 days before we get to the conference. If this paperwork isn't uploaded, they're going to dismiss our case. So what we are going to start doing and what you are going to see, and part of why we wanted to have this conference, is when we do the complaints for you guys and Diane sends them back for you to review and sign off on the,
Landlord
the
verification.
verification. I couldn't think of the word. Thank you. On the verifications, we are then going to ask for these documents. We're going to start asking for them very early at the point you file the complaint so that Diane can upload them immediately and not have to worry about them, because we do not want your cases being dismissed. They were being very lenient through the fall. They're not going to be lenient anymore. So we need to get these documents uploaded basically at the times we file the complaints so that it's not something we miss. So you're going to see that coming from Diane. If she hasn't already, very shortly, that says, hey, here's your complaint, please verify it, sign the verification. Oh, and by the way, I need these other 6 documents as well. So just keep an eye out for that. Again, everything keeps changing. So in the middle of Diane trying to file a warrant of removal a few weeks ago, it got rejected because that particular county is now requiring everything to be filed not only in English, but Spanish as well. They did not give us a heads up about that. They did not tell us. They did not give us notice. They just said, oh, by the way, your filing is rejected because it's not in Spanish as well. So she had to go back and get the form translated into Spanish and upload it in Spanish as well. So this is kind of what we're dealing with at our office. Prior to COVID hitting, our rule in our office, and our girls lived by this tenet, was everything needs to be filed within 24 to 48 business hours of when we receive it from you. And by filed, I mean back in your hands to be verified. That obviously is just not possible right now. It's, with us having to upload all of these documents for every one of these cases and us having double conferences plus hearings on every one of these cases, we are at a severe backlog to try and dig out of the hole that we were in from this 70,000 case backlog. And now obviously the new cases are coming in. I do anticipate we'll get back to what that used to be once we can get everything caught up. And once the courts are caught up, because the courts are, depending on the county, Burlington's completely caught up, I believe, as of a couple of weeks ago. They said other counties aren't even close. I'm still doing cases that we filed prior to March 2020 in other counties. I had one last week, and we had the docket said 2020. So it means we filed it in like February of 2020 before the courts shut down. So some counties are incredibly behind still. And some counties, Burlington, I think, is pretty much like the example that all other counties need to follow, because it clearly is a pretty populous county. It's not like it's one of the little smaller ones. And somehow they've managed to just streamline. They're amazing. They're absolutely amazing. So we're kind of dealing with, it all over the map. And it's a little difficult to navigate, but we're getting there. So that's just a quick, brief update on what's going on, from a procedural and a paperwork standpoint, just so that you guys can be familiar with what you're seeing as it comes across from Diane. Di, do you have anything else? Did I miss anything? from that
No,
perspective.
no, I just be patient with me. I'm working my best and I appreciate everybody. That's all I got.
Yeah, just so you guys know too, Diane worked Saturday, Sunday of this last weekend. I think she's worked every weekend since the fall, nights as well. I'm getting emails from her at night. And she is going on vacation this weekend, and she deserves it more than anybody I know. So be patient with Marley next week as she steps into Diane's role and tries to deal with this. But our office has to go hit with COVID. Everybody but 2 people in our office, one of which is actually Diane, got COVID right after
Didn't
Christmas.
get
So we
COVID.
had, yeah, Diane was one of the few people who didn't get COVID. So
Was sick, though.
basically,
She still got sick.
it basically, huh?
She was sick, but not with COVID.
Correct.
But not with COVID, right? So it basically ran through our office right after the holidays. So we had the holidays and then we had COVID. So that kind of messed us up a little bit too. But luckily not as bad in New Jersey because Diane was one of the few people that survived. So survived not getting COVID, I mean. Okay, Matthew, where are you? There you are.
A quick few
I
procedural,
know,
really quick.
quick.
Hold on, Kim, one second, Kim. I just want to go through a few things that Janelle touched on real quick. As far as the backlog in courts, I want to let everybody know that this week we just received dates for Monmouth just for CMCs for the end of March for some cases that were in 2020. So please know, New Jersey, we do not pick dates. If any of you have properties in the districts that you also work with us for, you know they have to be scheduled within 7 to 15 days. That, of course, is not the case in New Jersey. So know that those dates are not coming from us. Also, with that, the way that New Jersey does certain mailers and what have you, we find out certain things very last minute. So if Diane or myself are sending you a 911 email of documents that we need, we hope this doesn't happen, but please know this isn't, hopefully on our end, we didn't drop the ball. It's coming to us as quickly as we can get through it. A few other things, the complaints you are now going to hopefully be receiving, you're used to getting approvals with just the complaint on there. For the new system in Jersey, it's actually going to be easier for us to send over the complaint and the summons together. You can ignore that. You're still going to approve the complaints as you always have. It's just easier on our end to send it over that way. This will be a disclaimer in the email, but since we're all together now, I do want to let you know. Just another thing to touch on as far as our office goes, the girls work endlessly and tirelessly. They are amazing. I appreciate everybody's grace and patience with all of us. I know your staff has been hit with COVID as well. Di was out sick. Half of our staff was sick. And yes, she did mention Di is going on vacation next week. That does not mean that we will not stop processing your work. However, of course, as you can understand, the head of my New Jersey department will not be here. So I do have myself, and you'll also be starting to work with Emily, who's going to be joining our New Jersey department you'll hear about. But please know you'll be hearing from me, maybe on Diane's email next week. I will be getting your emails, reviewing them, and processing work. But just please know that that's what's kind of going on our office.
Be patient with Marley is what she's saying.
And I think we're also supposed to get like a big snowstorm, maybe Sunday night. Now, my staff does work remotely, but of course, certain things are easier to handle in office. So that's also being thrown on us as well. I'm sure there's a new variant coming, what have you. So just that. Kim, what was your question real quick? We can see it, or if anybody does have a question, please write it in the chat. We are going to be monitoring the chat throughout the whole seminar now. So if you want to write a question in there, we will answer it at the end.
But go ahead, Kim, you
Perfect.
can go ahead and ask it.
Yay! Okay, really quick. What can we do to eliminate you having to come back to us? Can we go ahead and send, like, when we're sending you the ledgers, the leases, can we just send you the registration attached to, like, we should send you an entire packet that gives you everything
Yeah,
you need.
Agreed, Kim, and we're going to get there. So we're putting that packet together from our office so that when we send you over the complaint, we're going to have right in the email, hey, we need you to verify this because you have to send that verification back anyway and give us this, and this as well. So yeah,
Okay.
I mean, that's what I was.
Just so we can help.
I appreciate
No,
it.
I
do.
was just thinking on
Thank
my
you.
end. Yeah,
Yeah.
we want to help. And I can confirm the Spanish and the English translation, that was my case, and we got it.
Yes.
Yeah,
We
that
did.
was yours that got rejected on.
That
Yeah,
was mine.
Yeah, thanks for the heads up, Courts, but this now needs to be in Spanish. So yeah, so well, good. That's a nice little testimony on thanks, Kim. So yeah, that is our goal so that we're not hounding you guys. It is gonna, we got to get everybody used to it, including my office, but it's gonna be, hey, here's your complaint. And when you send back that verification, you guys are just going to be used to sending back these 6 documents that we need, or however many it is. So we're putting that together now, and it's a great point. And thank you, Kim. Okay, a couple questions before what?
It's going to be a learning curve, obviously, in having to send new documents over. But how we run our Philadelphia department, the volume is so large. We need 4 documents in Jersey. Philly needs like 10. It's insanity. So I would like New Jersey to be the same, as we'll put it together for you and let you know if you're able to send it all in the beginning or at the approval, and we don't have to keep following up. That helps expedite your cases even quicker. So it's worth it to not even send it back until you have that. That way we can have everything at once. Also, I've been noticing for a lot of people, there has been a very large delay in approvals. We will be following up, about twice saying, hey, do you approve this? But then we will be waiting back just due to the volume. So please just keep an eye on that. And the quicker you can approve them and get them back, the quicker we can get them into the courts, quicker dates, et cetera, et cetera. That's
okay,
all.
a couple questions here. Are the residents required to appear at the conferences? Yes. So it's actually a good point. We don't need you guys on the case management conferences. We just need those documents. We'll get them uploaded. We can handle the conferences. The residents are supposed to log on. That is not to say they are all the time. In fact, I would say the ones I've handled, I've seen it probably 60% of the time they're on, 40% they're not. They don't dismiss the case. If we don't appear, we're in trouble. They don't appear. They just schedule it for trial. They do not give us possession at that stage. However, we can settle it at that stage. So you may get a phone call from us and just say, hey, tenant's willing to leave on such and such a date. Are you good with that? Or, hey, tenant's willing to pay all this by such and such a date. Are you good with that? A lot of the times things were getting pushed because of rental assistance, and things were getting pushed because they're filing these certifications. Matt's going to talk a little bit about the certifications, whether he realizes that or not, and when that ended and what that means for you guys. In a moment here, but this is becoming less and less of an issue now that we're in January with regard to those certifications, and obviously the rental assistance will start phasing out as well as they run out of money. So, we can settle it at that time. Certain counties push it more than others, but for the most part, they just ask us for a ton of information. How much is owed, what's the lease term, blah, 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 blah. Ask the tenant if they've applied for rental assistance, and then they just set it up for trial. So that's what we're seeing. The trials on the Zooms, as of right now, we're asking you guys to log on. And some of you I know, I don't know who's on here. I don't know if Whitney's on here. She was sitting on a Zoom with me last week for about an hour and a half to take a default, but certain counties require us to put testimony on for a default. Other counties do not. So as of right now, since it's just Zoom, we're not dragging you guys down to court. We're asking you to jump on for the trials. And sometimes you say we need you, sometimes we don't. But just throw it on your computer, turn your camera off, keep working, and then when we need you, we'll scream and holler your name, and let's get it. Come put your camera back on and come back to the Zooms. Okay. All right. Other questions? After a resident files the DCA certification, the courts are on. Okay. Matt's going to talk about the DCA certifications in a minute, so just hold on with that. And the rest of this is all praise, and I love you guys for that. Thank you. It's been a really rough 2 years, so we really appreciate that you guys have been so patient, and you guys are wonderful to work with. So, all right, Matthew, you want to take it away and do your thing?
Yes, morning all. You'll be pleased to know, those of you who are on the last time I participated in one of these, I do not have screen sharing capabilities, so I will not be cutting off all 100 of you at once when I'm done talking, like I did the last time. Anyway, I do have some quick things to talk about first, and then I'll spend a couple minutes on the Fair Chance and Housing Act. First of all, as Janelle said, we're pleased that Riley is joining our team, and Janelle did touch on us kind of stealing her from the court system, but just so you know, she wasn't a janitor at the court. She was a landlord-tenant specialist. So just so you know, the case management conferences that Janelle was just talking about, they are conducted by a landlord-tenant specialist who is specifically trained in landlord-tenant law. And Riley was a landlord-tenant specialist for them. And as I'm sure you can imagine, we deal with tons of these landlord-tenant specialists. And Riley did stand out with all the ones that I was dealing with. And that's why we've brought her on our team. So we're pleased that she's here.
Yes.
Second thing I want to reiterate, I tell you guys this every time that we do one of these. If somebody has got a balance, a large balance, specifically a large balance, do not offer them a new lease. Do not offer them a lease renewal. Just let the lease continue on a month-to-month basis, because this creates the possibility of a waiver of your ability to evict them for the money that was owed before the most recent lease renewal. Now, Jackie, this is your opportunity to either look really smart or not. What's the name of the case from the appellate division that says that it's a waiver? She has herself on mute on purpose, so we don't know if she's right or not. Oh, go ahead.
I don't know. where she
Wait,
went.
am I unmuted? Okay,
Now
there we
you
go.
are.
Yeah, you're
Jason Town.
Jasontown, yes. Jasontown Apartments versus Lynch is one of them, and Montgomery Gateway versus Herrera is the other one. So,
And by the way, none of you need to know that. Matt's just being, Mr. Smarty Pants over there. You don't need to know the name of the case.
there will be a quiz when I'm done. So anyway, I wanted to tell you that there are no more security deposit being applied to the rent thing. That was Executive Order 128. This was a question that I had recently in the last couple of weeks. So yeah, that expired on August the 4th, because that was 60 days after the conclusion of the declaration of emergency in New Jersey. So no more of the security deposits. As far as the DCA certifications, so these should be petering out for a couple of reasons. One of the reasons is that part of the certification, and I want to clear up any confusion. There are two DCA things, okay? One is the DCA certification that is submitted to the court to have the case administratively dismissed by the court. The other is applying for rental assistance through DCA. So these are two separate things. In order to fill out the DCA certification, you have to certify that you have applied for rental assistance through DCA. The deadline to apply for rental assistance for DCA was the 15th of December. So these new DCA certifications that are coming in could possibly be challenged, because it's, as time continues, it's less and less likely that somebody has applied for DCA rental assistance because the deadline was December the 15th. The courts have been instructed by the Administrative Office of the Courts in Trenton to continue accepting these DCA certifications. So the onus comes on to us as the landlords to decide if we want to challenge the certification or not. That has to be done by way of motion, which we can do for you if you want. I mean, that a motion is a separate action from the complaint. So it's a different undertaking, but basically we can file a motion to the court, bring it to the judge and say this certification should be set aside because it's inaccurate. So you can let us know if that's something that you want to do if you get a DCA certification on one of your non-payment cases. Also, to be clear, the DCA certification can only protect a tenant from eviction for monies that were due through the covered period, which, if they complete the certification, extends through December the 31st of 2021. So January rent that's due will not be affected by a DCA certification. Also, any rent that may have been due prior to the covered period, which started March of 2020, also would not be covered by the DCA certification. All right, I'll go into the Fair Chance in Housing Act. A lot of you have been asking me about this.
Wait, Matt, before you do that real quick, because there's a couple questions on the DCA cert. Can you just, okay. So someone has said, if once the court dismisses the case, what's the next step regard to refiling?
Okay, so once the court dismisses a case based on the DCA certification, option one, by the way, is that we can sue them for the money in another court. And I'm going to answer your question, but just so you know, that's an option also. We can file the suit, a DC action, and get you a judgment for the money amount. We don't do the collections part, but we can get you the judgment if you want to do that for that money. If the DCA certification results in the complaint being dismissed, we can file a new complaint based on non-payment of rent for January or going forward any months after January. So today is the 13th. So if they haven't paid their January rent, and you want to file on them for January rent non-payment, we can do that to just get a place in line. But as Janelle said earlier, you know, it's going to be a while because, well, and it depends on your county also. I mean, if you're in Essex County, their backlog was 15 to 17,000 cases. So it's going to be a while. If you're in Hunterdon County, they only do 300 cases a year. So there's not going to, you know, their backlog might have been like 10 cases. So you're going to get a date quickly. It all depends
So,
on
and
which
the good,
county you're in.
and what you should do is file now because of those backlogs, because if they owe January and we're not getting into court until March, we can amend obviously to add February and March's rent. So you want to get in that line as quick as possible. Okay, one other quick question. On the DCA, I'm sorry, on the COVID rental relief program, are all applications still being processed that are in, or is it still a lottery system? Do you know?
The lottery system is continuing until they run out of money, if they run out of money. They did get about $750 million of your money as a taxpayer, but don't get me started on that. Anyway, yes, they've got plenty of money. So until the money runs out, the process will continue with the lottery system. But again, the deadline was the 15th of December. So no new applications after that deadline are being processed.
Okay, and two last things. One, with your non-renewals or just not not renewing the lease and letting it run out, what happens with HUD and tax credit properties for compliance purposes? So, you know, for these tax credit properties, they have to offer these leases, you know, can we just put something in writing? Go ahead.
That's a great question. I will give you an answer, although I'll tell you it's sort of a gray area because, as I'm sure you can imagine, this COVID and the delay and all that has caused new problems that we didn't have before. I would say in a situation like that, if your compliance with HUD is at issue, we could do a renewal and I could draft you a sort of an anti-waiver notice that we would give to the tenant that would say, look, we're giving you this new lease, but only because we're required to by HUD regulations. This is not to be construed as a waiver of any monies that are due prior to this lease renewal. So in a situation like that, I think that would really be our only and best option. But if you're not in one of those HUD situations, you're better off not chancing it.
Okay, someone wanted to let you know that you have a very impressive DVD collection behind you. And and then the
I'll
only
have
other
you
question.
know, it will not surprise you to know that they're in alphabetical order.
No, I'm not shocked at that at all, actually. And then the only other question someone said is that the program, do we have any concern that the program, there'll be another program that'll come out that will excuse cases filed after January 2022? We have not heard this yet. I mean, I guess anything's possible, but it doesn't look likely.
Yeah, it's not likely. As I guess you guys know, I used to work at Legal Services, so I still have contacts at Legal Services who I talk to weekly. And I've been asking them this for the past 6 weeks. Did you hear anything? Did you hear anything? They have not gotten any word either that anything else is coming down the pike. And I think they would know if it was coming. So I think I agree with Janelle, although I don't like to do that on a regular basis, that
Funny.
probably not. So
Okay.
anything else before we get into fair chance and housing?
No, that's it. Go ahead and take it away with the fair chance.
Okay. So fair chance and housing, and a lot of you have asked me about this, and I've sent information to a lot of you via email, but I'm going to give you the Reader's Digest version. So this was signed by Governor Murphy on Juneteenth. It makes it unlawful for housing providers to ask an applicant regarding their criminal history on any initial application materials or in any kind of application interview, initial interview, with the exception of drug-related criminal activity for manufacturing or producing meth on federally assisted housing property, or if they're subject to lifetime requirement to register as a sex offender. Other than those two things, you can't ask anything initially when you are considering an application. If they pass all of your other screening and those two prongs, those exceptions also don't apply, that's when you can get into the criminal history check. And so you would send them a conditional offer if they pass all the other screening and those two prongs of criminal. And then after the conditional offer, that's when you can do the criminal history, the actual criminal history background check. So just a reminder, some things that can never be considered in the criminal history context at any point during the process are arrests or charges that did not result in a conviction. Anything that's been expunged, anything that was erased through a pardon or vacated, any juvenile adjudications, or any sealed records. It also prohibits you from requiring drug or alcohol testing. I don't know of any of our clients that do that, but if you do, stop. So anyway, once you do the conditional offer, that's when you do the criminal history. Like I said, you have to provide a disclosure statement informing the applicant of this eligibility criteria for the unit, and that their criminal history is going to be checked, and that they have the right to dispute anything you come up with or to present any mitigating factors. There is a model disclosure statement which has been issued by the New Jersey Department of Civil Rights. And so, there's no sense in doing a different one. If they've given the model one, if we use that one, we know it's right, and that they won't come back on us for anything. So I would recommend using the disclosure statement that Civil Rights has come up with. So the only criminal records that you can consider when you're doing the full criminal record evaluation are convictions for murder, aggravated sexual assault, kidnapping, arson, human trafficking, sexual assault, endangering the welfare of a child. You can consider conviction for any crime that requires lifetime state sex offender registration. Now, this next part is where I've been getting a lot of questions, and I really can't give you the answers that you're looking for. You're saying, well, so what offenses can we count? What's the look back period? So a lot of offenses have multiple degrees. You can be convicted of, if you look on TV and you see people, well, they were convicted of 1st degree murder or 3rd degree murder or 4th degree manslaughter. I mean, there's different levels for different charges. So the way the Fair Chance and Housing Act has been laid out is that if it's a 1st degree indictable offense, you can look back 6 years. I'm not sick, by the way. If it's a 2nd or 3rd degree indictable offense, you can look back 4 years. If it's a 4th degree indictable offense, then that's a 1-year look back. You cannot look back for any disorderly persons offenses. So a lot of you have said, well, felony, misdemeanor. So in New Jersey, felonies are called indictable offenses and misdemeanors are called disorderly persons offenses. So you can't look back on any disorderly persons offenses. If after you review the criminal history, you decide that you want to withdraw the conditional offer, bear in mind that the evaluation from Civil Rights is going to be, is the withdrawal necessary to fulfill substantial, legitimate, and non-discriminatory interest? So, if somebody's been convicted of assault and battery, your substantial, legitimate, non-discriminatory interest is this battery occurred within the look-back period, the person was convicted, and I don't want it to happen again on my property. You just have to have an articulable reason which falls within the statutory criteria, so that if they file a complaint, if the tenant or prospective tenant files a complaint with Division of Civil Rights, we'll be able to defend it. If you're going to reject the application, at that point you have to perform an individualized assessment, and the factors have been set forth that you would evaluate as part of the assessment. These are important because when you send the notice of withdrawal to the tenant, again, there is also a model notice of withdrawal by Civil Rights, which you're probably going to want to use. You have to indicate the specific reasons for the withdrawal, and these points that I'm about to run through are ones that you want to touch on in order to show that you were in conformity with the statute. So it's nature and severity of the offense, applicant's age at the time of the offense, how recently the offense occurred, any information the applicant provided to mitigate the offense. If the offense happened in the future, would it impact the safety of other tenants on the property? And when the offense happened, was it on the property that they were renting, or was it somehow connected to the property they were renting? So upon doing that individual assessment, if you decide you want to withdraw the conditional offer, you can do that. And again, I would recommend using the notice of withdrawal from Civil Rights. Then after the applicant gets the withdrawal notice, they have 30 days to dispute it or to request from you the documents upon which you based your decision. If they request those documents, you have 10 days to give them the documents they've requested, and you can't charge them for the documents that they've requested. And if they appeal it, then you can, go back through the documents again, have a discussion. If they appeal it, theoretically, they would be appealing saying, well, no, you didn't consider this, or look here, or here's some new information. If they just appeal
hey, it's not me. I've seen, hey, it's not me. This is a different Bob Smith.
Yes, right. So, you're going to want to reconsider based on new information. If they don't give you any new information, you just say, wait, we looked over the information again, and we've arrived at the same conclusion. So you have to provide the determination on the appeal within 30 days. Then If the prospective tenant doesn't like it, they can file a complaint with the Division of Civil Rights within 180 days of their final denial. And then we will navigate those waters when we get to that point. So does anybody have any questions? Is anyone even awake still?
Well, hold on, yeah, there are some questions. Number one, what is considered a conditional offer?
So the conditional offer is we have run your credit, your rental history, and based on those, you would be eligible for residency at property X. So therefore, we're pleased to give you this conditional offer. Now, here's a disclosure statement telling you that we're about to look at your criminal record, and a final offer will be made or not made, predicated upon the results of that.
Okay. Does the criminal background check need to be processed after the initial acceptance letter is produced, or can the whole background be ran and our analysis of the criminal history part of it only once we issue the initial letter?
I think it would be safe to hold off on the criminal background check until later, because this is all new, and I don't need to tell you that in New Jersey, everything is interpreted in favor of the tenant. So Lord knows we don't want to run somebody's criminal background and then all of a sudden we hear them say, oh, now I have emotional distress. Every time I hear the word criminal background, I pass out and bark like a dog or whatever. So yeah, let's err on the side of caution.
Okay. Does the conditional offer need to be in writing? Yeah, I would
Yes.
put that in writing. Yeah. And then there's actually a question that came across just as you started. All right, hold on a minute. The questions are popping up just as you started this, but it's not about this. Any information on the eviction and homelessness prevention certification forms for residents?
So again, the courts have been instructed to continue accepting them. But as I said, they're going to peter out because part of that form is certifying that they've applied for rental assistance. If the form's not accurate and you want to challenge it, we can file a motion.
Okay. And then last question, if they fail credit or income, can we deny right away without, I'm sorry, more questions are coming in, it's jumping, without running the criminal background? Yeah, you don't have to run the criminal background if they don't pass anyway.
Correct. If you don't get that far, you don't get that far.
During the whole appeal process, are we required to hold the vacant unit for them, or can we move on to the next applicant?
See, this is one of those, because this is all new.
And just so you know, they're saying that's a tax credit property, which I'm not sure it's going to
that
matter.
part- Yeah, that won't, I don't think
Relevant.
that makes a difference. And in this case, because this is all new, this is sort of an unanswered gray area. I
Yeah.
mean, if you have the unit to hold, I'd say hold it. If you don't, we can run the rapids and see what happens. I mean, if they're ultimately approved, and then we say, well, you've been approved, you're on the waiting list. I mean, we can try it. I mean, I don't think that's, especially because, the tenant advocates are always saying, oh, there's a housing crisis. There's a housing crisis. So, our answer could be, look, there's a housing crisis. We can't just sit around with units open while we wait to see if Johnny Smith over here has ever held up a bank.
I like that. Okay, that is it for the questions. And look, guys, I said 20 minutes, maybe half hour, 37 minutes, not too bad. I knew it would go over a little bit. So anyway, as always, if you have additional questions, you can shoot an email to Matt if it's a legal question. If it's a question about the process, shoot an email to Diane. We'll get to you as fast as we can. I know Matt's going to hang this up and get in a car and drive pretty far for court in a few minutes here, but we're always around. So just reach out to our office if you have additional questions. And we really thank you for jumping on. It's just easier to kind of inform all of you at once when there's these big of changes and when everything's kind of changed in the last 6 months, and emails can be very confusing. We try and do that for little issues, but when there's this much going on, we figure a Zoom would help. And if anything significant, changes over the next, month or two, just keep your eyes out. We'll host another one of these because I think
Just a
it's
suggestion, if you're going to email me with a question, CC Jackie on the email, because number one, she'll make sure I don't forget it. Number two, she works pretty closely with me on this stuff, and some of your questions she can probably answer, and she'll get back to you faster than I will. So
yeah,
you may wanna
it's a
put it on
good
there.
point. Always kind of CC either Jackie or Marley if you're emailing either one of us from the office, just because because of this backlog, us attorneys, me, Matt, Riley, we're in court all day, every day. Today is actually the first day I haven't been in court, I think, since before November. It's been crazy. So try and, reach out to the office first. And then if they don't know the answers, they'll get in touch with us. They know how to bug us a little better. So Marley's got me on speed dial, I think. So, all right, guys. Thank you. Oh, Jackie, what did you want to say, hon? I'm sorry.
I just wanted to touch on the DCA registrations that are required to be uploaded prior to court. Those property registration paperworks.
She's talking about
So-
landlord, she's talking about landlord registrations through the Bureau of Housing Inspections.
Yes, so they're required for the filings, and this is something that Cohen Marasini actually recently just took on as part of our daily workload. So if your property is not registered or you're unsure if it's registered, please reach out to myself and Matthew, and we can either do the whole registration process for you. We can look up to see if we can even retrieve the documents if the property is registered. But if you have any questions about the actual building inspection registration certificates and whatnot, please reach out to us as well, because I know now they're required for court too.
They are, and that's a great point. We need those before we even get to the conferences. So that's a great point, Jackie. Thank you. Okay, guys, thank you. I'm going to end this. Appreciate it. And thanks to everybody for all your wonderful comments in the chat. It really does make our day. You guys are awesome.
It does.
All right. Bye, guys.
All right.